Hey, welcome back! Today, we're breaking down the legal administrative process in court, the steps that keep cases moving behind the scenes. Whether you're interested in law or just curious about how things work, understanding this process is crucial. It's the invisible backbone of the legal system, and it plays a huge role in ensuring that justice is done efficiently, fairly, and by the book. So, what exactly is the legal administrative process? In short, it's everything that happens behind the scenes to keep a court case on track. It includes filing important documents, serving notices to the right parties, maintaining accurate records, and ensuring that all the rules and timelines are followed. If even one of these steps is skipped or delayed, a case can stall, or worse, be dismissed altogether. Think of it as the operating system of the court. Without it, nothing would function. Judges, lawyers, and juries may get the spotlight, but it's the administrative process that sets the stage for everything else. Let's walk through the key steps of the legal process, from the first filing to the final judgment, and everything in between. Step 1. Filing the complaint. Every court case begins with a complaint. This is a formal legal document filed by the person bringing the case, known as the plaintiff. The complaint outlines the nature of the dispute, identifies the defendant, and states what the plaintiff is asking the court to do. That might be monetary damages, a specific action, or a court order. Once the complaint is filed, the court assigns a case number. This number acts as the unique ID for the case and will be used throughout the entire legal process to track everything from motions to verdicts. Step 2. Serving the defendant. After the complaint is filed, the next crucial step is serving it to the defendant. This is called service of process. It ensures that the defendant has official notice of the lawsuit and has a chance to respond. The law requires that this step be completed properly. It usually involves a process server or sheriff delivering a copy of the complaint and a summons to the defendant personally. In some cases, other methods like certified mail or even newspaper publication may be used, but the key is that it must be verifiable. Without proper service, the court can't move forward. It's a constitutional requirement. Due process demands that people are informed before legal action is taken against them. Step 3. Responses and counterclaims. Once the defendant has been served, they have a limited amount of time to respond, usually 20 to 30 days. Their response can take several forms. They might admit to some or all of the allegations, deny them, or provide an explanation. They may also raise defenses, legal reasons why they shouldn't be held liable. Sometimes the defendant goes on the offensive and files a counterclaim. This is basically the defendant saying, "Actually, you wronged me." Now the court must consider both the original claim and the counterclaim as part of the same case. Step 4. Discovery. After the initial pleadings, the case moves into the discovery phase. This is when both sides exchange information that's relevant to the case. Discovery can include written questions called interrogatories, requests for documents, admissions, and depositions, which are sworn statements taken outside of court. It's all about uncovering the facts and building each side's argument. Discovery can be long and detailed, especially in complex cases, but it's absolutely vital. It prevents surprises at trial and helps promote fairness by making sure both sides have access to the same evidence. Step 5. Pre-trial motions. Once discovery wraps up, the parties might file pre-trial motions. These are formal requests asking the judge to make decisions on certain issues before trial. Common motions include motions to dismiss the case or parts of it, motions to exclude certain evidence, or motions for summary judgment, which ask the court to decide the case based on the facts already available without a trial. Pre-trial motions can reshape the case significantly. Some motions resolve key issues or even result in early settlements. In many cases, effective motion practice can prevent a trial altogether. Step 6. The trial. If the case hasn't been resolved through motions or settlement, it goes to trial. This is the part of the legal process most people are familiar with. The courtroom, the judge, the attorneys, the evidence, and possibly a jury. During the trial, both sides present their arguments, examine witnesses, and submit evidence. The judge or jury listens, weighs the facts, and applies the law to reach a verdict. Trials can be short or long, simple or complex. Some last a day, others can stretch on for weeks or even months. But regardless of length, the goal is the same: to reach a fair and lawful decision based on the evidence and legal standards. Step 7. Judgment and appeals. At the end of the trial, the court enters a judgment. This is the official decision: who wins, who loses, and what the remedy is. That could be an order to pay money, perform a duty, or stop doing something. But the story doesn't always end there. If one side believes there was a legal mistake, for example, improper jury instructions or a ruling that excluded important evidence, they can file an appeal. Appeals are handled by higher courts. They don't re-examine the facts, but instead focus on whether the law was applied correctly. In the original trial, if the appellate court agrees that an error occurred, it may reverse the judgment, send the case back for a new trial, or even dismiss it altogether. Behind the scenes. While all of this plays out in courtrooms and legal filings, a huge amount of work is being done behind the scenes. Paralegals, legal assistants, court clerks, and administrative staff handle the mountains of paperwork that move through the system every day. They file documents, schedule hearings, maintain case files, and manage legal calendars. These professionals are the organizational backbone of the court system. They ensure that filings are made correctly and on time, that notices are served, that records are complete, and that deadlines are met. Without them, the entire system would slow to a crawl. Legal administrative professionals also play a key role in communication. They help coordinate between attorneys, clients, opposing parties, and the court. Their efficiency can make or break a case timeline. Many lawyers start their careers in these roles, learning the ropes of how the court system functions day to day. It's a great way to gain real-world experience, and it's a vital part of the justice system. Why this process matters. The legal administrative process may not be as glamorous as courtroom drama, but it's what makes justice possible. It ensures that everyone gets a fair shot, that cases move forward in an orderly way, and that courts operate with integrity. From the first complaint to the final judgment, every step matters. Deadlines must be met. Papers must be filed properly. Evidence must be shared. And rights must be respected. This process protects people from being railroaded, forgotten, or treated unfairly. It's one of the reasons why the rule of law works. And when you understand how it all fits together, you start to see the legal system not just as a set of rules, but as a living, working structure that depends on careful administration to function. So now you've got a solid overview of the legal administrative process, the behind-the-scenes engine that drives every case from start to finish. Whether you're planning a legal career or just want to understand how justice is delivered, this knowledge is a powerful foundation. Because when you know how the system works, you're better equipped to use it, navigate it, or even change it. If you found this helpful, don't forget to like, share, and subscribe for more content that breaks down the legal world into clear, practical insights. And if you have questions or topics you'd like to see next, drop them in the comments. I'd love to hear from you. Until next time, stay curious, stay informed.